In today's video, we discuss how multidisciplinary clinical healthcare practices can be profitable without running afoul of legal rules prohibiting corporate practice of medicine and prohibitions against kickbacks and fee splitting. When we talk about multidisciplinary clinical healthcare practices, we're talking about health and wellness centers. For example, any combination of the following: a medical doctor, chiropractor, nurse practitioner, naturopathic medical doctor, licensed acupuncturist, or other licensed healthcare practitioner. Your own center might be focused on integrative medicine, functional medicine, a mental health or behavioral health center, a clinical center focused on fertility, weight loss, sleep, or any other kind of specialized approach. Some clinical centers are very large with many different kinds of healthcare practitioners working side by side. Others are small with perhaps one medical doctor and a chiropractor collaborating on improved function, pain management, or stem cell techniques. I'm Michael H. Cohen, founding attorney at Cohen Healthcare Law Group. All we do is healthcare and FDA law, with hundreds and hundreds and hundreds of healthcare clients every month. We provide legal advice day in and day out to healthcare businesses and practices just like you. And one of the areas where we have an edge is the multidisciplinary health and wellness center. Now, this might be because I started my career in healthcare law counseling integrative medicine centers, which eventually led to the honor of a faculty appointment at Harvard Medical School, which just then was embarked on research and education into integrating complementary therapies into conventional care. One of the key legal issues that a multidisciplinary healthcare clinic or center faces is corporate practice of medicine. The corporate practice of medicine doctrine prohibits companies other than professional medical corporations that are owned and operated by MDs from practicing medicine. And there's a similar prohibition against the practice of medicine both by unlicensed practitioners and by licensed practitioners who are not MDs. The anti-kickback and fee splitting issue runs in tandem with the prohibition against corporate and unlicensed practice of medicine. The rule is basically that a licensed healthcare practitioner cannot split their professional fee with non-licensees, such as, for example, the business that is managing and marketing the center as a whole, or with the individual practices, but there's some exceptions to that. We'll get into it in a moment. Because of these legal prohibitions, when clients come to us with a multidisciplinary clinical operation, these are the kinds of questions we might ask them to ferret out the business model. Who is it that the client would like to own the center? Is it one of the healthcare practitioners? Does that healthcare practitioner own a professional corporation? And are the other healthcare practitioners employed by that professional corporation? On the other hand, is there a management services organization, or MSO, a business arm, that runs the whole facility and is responsible for managing and marketing the center, including the individual practices? To give a concrete example, sometimes the client that comes to us is a chiropractor looking to partner up with a physician, so to speak, who can provide stem cell therapies. One variation we've seen is a licensed naturopathic medical doctor looking to partner up with a medical doctor to provide regenerative medicine services. In these situations, the chiropractor cannot legally practice medicine, and the naturopathic medical doctor might be legally prohibited from supervising registered nurses or from performing stem cell therapy. So one big question is, how do they collaborate in a way that assigns the medical procedures to the medical professionals whose licensure allows them to work these therapies and limits other practitioners to their legally authorized scope of practice? We can sort out the scope of practice issues in various legal agreements between the professionals, as well as in the various ways we can structure the professional corporations that house those professionals. Among other things, in California, we rely on the Moscone-Knox Professional Corporations Act to mix and match practitioners with a professional corporation, or PC. As well, we typically use the MSO model to separate the business from clinical functions and clarify the flow of payments so that the business arm is hired by the professional arm, in this way mitigating concerns about fee splitting. If the center is simply a location that rents space to the various practitioners, then the MSO, or General Business Corporation, or LLC, that owns the master leasing the equipment cannot practice medicine. Again, that's because the law prohibits corporations other than professional medical corporations from practicing medicine. If this still all sounds a bit mysterious, and I've gone rather quickly through some of the law, you can go to our blog, cohenhealthcarelaw.com/blog, and see lots of articles, posts, and resources explaining the MSO model and how we use it for multidisciplinary healthcare centers, as well as for medical spas, telemedicine, and other healthcare businesses. Once again, we're grateful to you for watching. If you still have questions, and no doubt you do, click on the link below, cohenhealthcarelaw.com/contact, to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.